Yes.
May I please, your Lordship? Lordship, I beg to mention item 2 of the daily trustee. In this matter, we intend to file our rejoinder affidavit, Lordship.
Item 2.
Yes, Lordship. This matter may be adjourned for 4 weeks. We have taken consent from the other side also.
Okay, with the consent of other sides. Mr.
S.K. Chakma.
S.K. Chakmal and counsel for the petitioner.
On
Yes,
behalf,
sir.
I'm appearing on behalf of the.
Place for adjournment. So as to enable him to file affidavit in reply. Prayer is allowed. List after
4 weeks, Lordship.
4 weeks.
Deeply obliged.
Daily list item number 1 for admission.
May I please, sir. This petition of infections must have already, result have been declared.
Okay. Upon instructions, Mr. J.U. Ahmed and counsel for the petitioner submits that as results have been declared, the matter has become infructuous. According, Ms. R.B. Boral and standing counsel for BTC and Mr. U. Sharma, then is standing counsel for respondent number 1 and 3 are present. Matter since dismissed, having been rendered infructuous.
Okay.
3 and 4.
Kindly method password for the time being.
Okay, just be here, both sides are there.
This lordship, Mr. ARB is on lag. So kindly, may your lordship pass over the matter for the time being.
Okay, you are also for time being. Okay. Okay.
Item number 5 for others.
Yeah, please, Lordship.
Yes.
Lordship, in this case, the respondent by 9, Director of Education BTC is the ultimate authority to disperse the salary, which was directed by the Honorable in the repetition. Lordship, here I have submitted my representation while furnishing the copy of the order, Lordship. Member of our association is Lordship 681. But subsequently, the BTC authority has filed an affidavit stating that they have submitted proposal for 314 mother teacher Lordship. But I have come to know that most of these 314 are not the member of our association. The direction is to pay the salary to the members of our association, Lordship.
No, how will they identify the members of the association? It will be uncompliable order.
Lordship, I have in the requisition I submitted the list, Lordship, to who are the members. So finding those members, Lordship, who passed the order. That list is before the read court, Lordship.
Where is the order of the court?
Lordship.
Which page?
Lordship, page 40, Lordship.
40.
Operative part is page 42, Lordship. 7, paragraph 7.
Yes, who is for BTC?
So Lordship, today my prayer is that DC may be directed to submit the list of 314 teachers to
In a contempt petition. No,
contempt petition, Lordship.
there is not an inquiry I'm going to make in a contempt petition.
Lordship, I can verify from my petition that those 314 member the mother
Get it from any other source, but in a contempt, I won't go into that inquiry. It's beyond the power of the court.
Lordship, if they have not submitted the proposal for our manager, that is only contempt of court, Lordship.
So that's why we go ahead with the contempt.
So I have already informed what Lordship by my representation, Lordship, kindly see the representation, Lordship, at page 44. Page 45, I have stated, Lordship.
Mr. Your name?
I further stated that we have submitted a
name,
list
your
of
name?
member of our association.
Mr. P. Bora. P. Sharma,
Yes, sir, my lord.
learned counsel for the petitioner, submits that till date, the order of the court dated 18/1/2019, passed in WBC 7804 of 2016, has not been complied with. Yes, your for Mr. Das.
Respondent number 18 year old. So if I'm allowed, I can place some documents to show that amount has been sanctioned here, Lord, the area salaries.
Show me that.
Yes, Lord.
Respondent 18.
Respondent number 18, present chief secretary, Your Lord. Assam. Second one is the sanction, Your Lord, order dated 23rd of March.
No, this will not help you.
Lordship.
This will not help you.
Direction was to release the area salary, Your Lord.
No, look at page 2 of the contempt petition.
Yes, Your Lordship.
Non-compliance of order dated so and so passed in WBC 7804.
Correct, Your Lord.
No, the document you have given me is not for this case.
But it's, Your Lordship goes to page 7, page 1, Your Lordship, subject. It's ordered. Contempt case
496.
number is mentioned, Your Lordship. The first letter, Your Lordship, of the bunch I've handed over, Your Lordship. It in compliance of the High Court case number 496 2019.
Lordship, yeah. In this case, instruction is with S. Bora, Lordship. Please, another for Lordship, kindly pass over for time.
Mr. Das, you
Yes.
see the impugn order,
Yes, Your Lord.
but not impugn order, the order which has not been complied with.
Yes, Your Lord.
Now, this page 41,
Yes, Your Lord.
about 8 to 10 lines from below. Amount is rupees 33,42,65,001.
Yes, Your Lord. If Your Lordship go, if Your Lordship have a look at paragraph 7, Your Lordship, of the order. Third from the last. The aforesaid paragraph 7, Your Lordship, third from the
Yes.
last. The aforesaid direction requiring salary, release of the area salaries, Your Lord.
Yes.
This is the mentioned is the area, the sanctioning of the area salary, Your Lordship. Second, the later is the 23rd of March 2023.
Yes.
First page is for sanctioning of the payment of area salary. Second letter is the sanction, Your Lordship, order. Passed by the secretary, BTC, Your Lordship. Now the petitioner has to establish their claim, Your Lordship, before the concerned authority, the association, who are the members. They are saying that some other
No,
people are
Lordship,
getting.
direction was to pay.
Please, I am asking him, Mr. Sharma, I am not habituated to continue debate.
Sorry, Lordship.
Am I asking, I will put a question to you. If you want to say everything, Mr. Das, you sit down.
Yes, sir.
Sorry, Lordship.
Yes, you make your argument.
Sorry, Lordship.
No, now do it. No, I'm
Sorry.
giving you an opportunity. You have a free hand.
Extremely sorry.
I'm asking question in your favor and you are again disturbing me.
highly
The
of high-
entire thought process you have changed.
sorry.
Yes, your lordship.
Mr. Das, you see, we are in a contempt proceeding.
Correct, your lordship.
Now, there is an order of the court where a reference is made to say 10 rupees.
Correct, your lordship.
And you say that it is in compliance with not of that writ petition, you are saying in compliance with the contempt
Contempt
petition.
case, as mentioned in the letter, your lordship.
Yes, in the contempt case, have we quantified 33 crore to be 1 crore,
No, not mentioned, your lordship,
not mentioned.
not mentioned.
So therefore, why will the petitioner have to go to the officers and satisfy?
Correct, your lordship. But they have to satisfy, they are saying that the members of the association they are not entitled. They are saying the other people have been, names have been mentioned for mentioning of the amount. As claimed by the petitioner, your lordship.
No, they have filed a contempt that you have not paid my members.
That part has to be said, placed before it by the counsel for the BTC, your lordship. Or who appears for the concerned officer of the BTC, your lordship.
They will definitely not answer unless we call them personal appearance. BTC is not going to answer the court unless we ask for the personal appearance.
As I was looking after this matter.
Okay,
from the
after some
beginning-
time.
Beginning, lordship.
Okay, after some time. Okay. But please give us an answer.
I.
Please give us an answer. Because after
Correct.
filing of the contempt,
Correct, your lordship.
if the petitioner has to run
Correct, your
everywhere,
lordship.
then it is better we call them
Correct.
instead of petitioners running. Let the BTC people be here. Because now it has come, Mrs. Bora, this come to such a stage that people who are in the administration, they are looking at not only the name of the court which is passing the order, they are also looking at the names of honorable judges who are passing the order. And then they said, oh, this should not be complied with. Justice so and so, oh, don't comply.
Lordship,
Justice so and so, okay, comply.
that man.
Correct. And it is in this court we have seen a stand taken in the morning,
No, that's
being changed in the afternoon, when the court says that at 2 o'clock, come and give me compliance. Those days also we have seen. I don't know whether you have seen those days or not. In one particular court, compliance would be made by 2 o'clock.
Sorry, lordship.
Hmm. So we'll have to enforce those things.
Our officers are not doing well. That is also true, lordship, but I'm very sorry for that loss.
No, but your sorry wouldn't help the petitioners. If 33 crore comes to 1 crore, they have to give some explanation.
Correct. That mentioned, but that.
And because you see, I'm more serious about the fact, because you have now said that it is in compliance with. So once it is compliance with, you show me that it has been complied with. Mere statement won't do, because they will go to, what do you call, they will be sent to some place.
Okay, here. After some
After
time.
some
lordship.
time, after some time.
Six.
Yeah, please, your lordship.
Yes,
Here, while this contempt petition was filed, Mr. Nitin Kumar Shivdas Khare was the commissioner and secretary
yes.
for the Government of Assam Finance Department. But by the time we filed it, lordship, he has already vacated his office, he was transferred. So we filed an IA, lordship, for impleading Mr. Shyam Jagannathan, and that was allowed.
Okay.
But now, lordship, a report has come. In fact, an envelope has come. I have phlegmaed the envelope. Addressee has left, lordship. So I think I will have to
Can
again
you,
take the.
can you get the name?
course. Yes, lordship. I did not get the name, but one Mr. Mathur has joined. I have come to know. Thakur, Mr. Manish Thakur has joined,
Manish Thakur.
lordship. But I think, lordship, again, the judgment of this honorable court that against a representation need to be sent to him. If he comply by that, then obviously this will become infectious. So if to follow that recourse, lordship.
Okay. Mr. A. Bhattacharya, the counsel for the Bhattacharya G. You read J double or YA?
Why, lordship?
Y, okay. Bhattacharya,
AWD is my
counsel for
brother.
the petitioner submits that the new incumbent to the office of Commissioner and Secretary to the Government of Assam Finance Department
Lordship.
upon whom notice was served after implement.
Notice was, Lordship, in fact, step was taken, but the report has come that he has left.
On whom steps was issued by registered post with AD has returned back with a postal remark addressing left.
Lordship.
So it is submitted that he has obtained instructions that a new incumbent has joined office, being Mr.
Manish Thakur,
Manish Thakur,
IS.
IAS. So accordingly, the petitioners are permitted to serve a representation of the new incumbent, requiring him to comply with the order dated 29/5/2018, passed in WBC 1284 of 2016,
Lordship.
and thereafter file an application for implement. Next, in the meanwhile, the petitioner is also permitted to ascertain the present address of the respondent numbers 1 and 2. And begin a record for issuance of process on the said respondents.
But the address that was mentioned, Lordship, was the official address that was available in the website.
No, you will get it. Officers can be tracked. You bring the, because if they have committed contempt, they'll also have to be proceeded against.
Development.
List after 2 weeks,
Because the representation includes
Okay.
4 weeks.
list after
Lordship.
4 weeks.
7.
May I please, your lordship?
Yes,
Lordship, the petitioner preferred under compelling circumstances, your lordship, the IA for slight modification of the condition number C and D of the bail order granted by dishonorable court, your lordship. C
Okay.
and D, your problem is this, your lordship, this is a very poor man, your lordship, no place to stay in Guwahati for long, your lordship. He has, in the meantime, he has regularly been appearing before the concerned police station, your lordship. It has also been recorded, your lordship. Now, your lordship, it has become very difficult for him to, if it can be modified to a certain extent, your lordship, if he can go back to his place and then come back in 45 days or.
okay.
Malak, otherwise, Malak, this is Malak, regular bail otherwise earlier, but whether subsequently he is Malak, cooperating with the IO or not, Malak,
You obtain
One-
instructions, we'll take it up on
Yes, yes.
Tuesday.
Lords,
Tuesday or Wednesday, Malak, and a report from the IO, Malak.
You take instructions instead of report.
Madam?
You can take an instruction over.
Instruction,
the-
instruction.
Mr. S. Bhattacharya and counsel for the applicant. And Mr. K. Parashar and APP appearing for the state. Next, this interlocutory application has been filed for modification of condition number C and D. In the order contained in the order dated 25/1/2023, passed in WBC, BA 25 What is the name? Bail
BA
application?
11 of 2023.
BA 11 or 2023? That's right. It is submitted that the petition, the applicant is of economically weaker section and he does not have accommodation at where? This is Guwahati,
Guwahati. Your Lordship. He is
Yeah,
from
yeah.
Kachar, Your Lordship.
at Guwahati. Accordingly, it is submitted that instead of appearing before the IO within 15 days, the period be modified to about 45 days for appearing before the IO. Next one. The Honorable AP shall take appropriate instructions in the matter. List on 11/4/2023. Next for the learned APP is permitted to send the downloaded copy of this order to the IO to enable him to obtain instructions.
Right.
Deep.
Eight.
Yes,
This review prepared by the state madam
yes,
against the order dated 2009 to 2016. Whereby the direction was issued to pay the salary to the respondent madam. So our only ground for review is that my lord, during the pendency of the writ petition, there was a
screening.
yes, madam,
He is
exercise.
not found in the list.
Yes, madam. Was
but
exercise
then-
undertaken by the department to find out the legality and validity of persons appointed during the year 1991 to 2001, madam.
But last time I posed you a question that there was an
Yes,
inquiry
yes,
which
madam. I have seen.
Hmm.
On that day, my lord, I was actually not prepared, madam. In
Hmm.
fact, I have read that paragraph, my lord. The only reason is that, my lord, paragraph 20. The government is in a dilemma as to whether the direction for payment of salary to illegal teachers found now after completion of the inquiry still needs to be paid, as it is a settled position that the illegal appointees do not have any enforceable legal right in service, including claims of salary as held by the Catena Supreme Court judicial pronouncement. This is the only ground for review, my lord. But in this case, difficulty is that the petitioner did not participate in the screening process. The petitioner did not participate in the screening process. As such, my lord, our genuineness of our appointment could not be ascertained by the screening committee, my lord. That is the only reason, my lord, to prefer the review.
the screening committee's proceedings was held when?
Advertisement was published, my lord, page 1 to 2012, annexure 5, page 44.
1 to 2012.
1 to 2012.
So this
Pursuant to office memorandum dated 15/11/2011, annexure 4, my lord. This is the office memorandum whereby guidelines were prescribed how to conduct the screening process, my lord. Pursuant thereto, the advertisement was published and persons applied pursuant thereto, my lord.
No, but you see,
Yes,
then there will be a slightly different question to you. You are saying that the screening took place in 2012.
Yes, madam. Advertisement was published 2012, madam.
No, it's okay,
Started in 2012 and completed in 2018.
2018.
Yes, madam. And the order under review was passed in 2016, madam.
See, the problem is that, that's why I told you that there will be a different question to you now. You see, in this proceeding,
Yes, madam.
you did not contest and bring it on record that this is a order of the court in the different petition, and he has to undergo a screening process.
Yes, madam. That is
Now,
clear, madam.
thereafter, when this order was passed, the screening was already being done.
Yes, yes. It was in under process during that time, madam.
So therefore, if once a leave is not taken of the court to have this person being screened,
Yes, madam.
this lady being screened, how does it make a case for review? Because for the purpose of review, the
That I
parameters you
understand.
know,
That I understand, madam.
it must be a error apparent on the face of record.
Yes, ma'am. In fact, yes, while yesterday I'm going through the brief, madam, in the impugn order, madam, I could find out a categorical finding of this honorable court that her appointment was legal, madam. In fact, that was confirmed by the order dated 6/7/2011, madam, by the Commissioner Secretary of the Department. That is why I found that, madam, this petition was allowed. But subsequently, she is also she falls under the same category. That's why her salary was held up during that time. In fact, in the earlier petition, there are 4 petitioners, madam, out of which the Commissioner and Secretary passed an order stating that the petitioner appointment was legal. Madam, may find that page 24, that finding of the Commissioner and Secretary, madam. Page 24. Second paragraph, madam. A perusal of the order dated 6/7/2011 would go to show that the said order was passed following the order of this court dated 14/12/2007, passed in WPC number 6364/2007, filed by the petitioner and 4 others. As per the said order, case of the petitioner were directed to be scrutinized by the expert committee constituted by the government following the decision of this court in Sudhendu Mohan Talukdar Supra. From the findings recorded by the departmental commissioner and secretary, it is evident that petitioner was a selected candidate selected by the subdivisional level advisory board Soraideo Sonari. Petitioner received her salary up to 28/2/2009 against a retired vacant post, and she is working in her school. On examination of the report and recommendation of the expert committee, the departmental commissioner and secretary decided that salary of the petitioner be released from the due date. However, it was decided not to make any order regarding payment of salary of the other petitioners. So this may be a reason, madam, that's why, madam, she did not participate in the screening process.
Now, where is this order of 6364? Do you have it?
Well, that order has not been annexed with the review petition, madam. It may be with the writ petition, madam. That order was extracted in the order, madam.
Yeah, it is available.
It's available, madam.
You can go through it then. Page 27. So therefore, this by this order at page 27,
Yes, madam.
this court directed the matter to be
Page-
examined.
Yes, madam.
No, matter to be examined.
Yes, madam.
So therefore, this what you call this examination took place with that expert committee,
Yes, madam.
and it was found that the petitioner is working. So why she would subject herself to a second process?
That is maybe, madam, that is the reason she did not participate in the,
Hmm.
because yesterday while going through the brief, madam, that I could find it
So
out.
we have to
madam.
close this interrogatory application, sorry, review application.
Yes, madam.
Just pass that order. But Mr. N.J. Khatuniat and standing also for the Elementary Education Department. None appears on call for the no, not a prisoner. It is in that although this review petition was filed on 12 January 2018, but notice has not yet been issued on the sole respondent, who is the writ petitioner in the connected WPC 4126 of 2012. Next part. This review petition is directed against the common judgment and order dated 29/2016, passed by this court in WPC 4126 of 2012 and other connected writ petitions.
There's only one writ petition, madam.
No, you see your cost title, you are saying from, I am reading from your cost title.
In fact,
I don't know, whatever you,
maybe, my lord.
by this said order. It's not a common order. This is not a common
It's not,
judgment.
otherwise, this is not a common order, my lord. Page 21.
Not a common. By so not other strike out that other connected decisions. So by virtue of the said order, the petitioner, the respondent number, the petitioner number 2, I, the Director of Elementary Education Assam, was specifically directed to release the due salary of the petitioner from the date of passing of the basic training course by the petitioner, less the amount already paid to her within a period of 3 months from the date of receipt of a certified copy of the order. Further directing that the current salary of the writ petitioner, I, the respondent herein, shall be released effective from 1/11/2016. Next one. The learned counsel for the petitioner has submitted that in the meanwhile, the division bench of this court by judgment and order dated 2/3/2010 passed in WBC 1048 of 2004 and another connected matters directed the matter relating to teachers who were illegally and irregularly appointed in lower primary and upper primary schools to be examined. And in the meanwhile, jurisdictional screening committees were appointed to examine the matter. And also directed that a policy be framed in accordance with law for accommodation of the 3281 numbers of illegally appointed teachers who have been identified on field verification. This led to a cabinet decision being taken in the meeting held on 26/2/2011 in compliance with order dated 2/3/2010 passed in WBC 1048/2004. And accordingly, with a view to examine the selection procedure, the nature of appointment, status of posts, working status, status of salary, academic qualification, etc. The petitioner number 2, I, the Director of Elementary Education, Assam, had invited applications from these illegally appointed teachers during 1991-2001 by publishing advertisements throughout the state. Advertisement dated 1/2/2012 throughout the state. So the learned counsel for the review petitioner has also referred to orders order dated 5/3/2010 passed in WBC 1457 of 2010. And it is submitted that the applicants moved this court with an interlocutory application seeking leave of the court to initiate process of recruitment in the provincialized elementary schools by relaxing the order dated 5/3/2010 passed in WBC 1457 of 2010. And as against order dated 25/1/2012 passed therein, the state preferred a special leave, a petition for special leave to appeal within bracket civil number within bracket small s 4340 of 2012 before the Supreme Court of India. And the said court by order dated 5/3/2010 lifted the restrainment order dated 5/3/2010 passed by this court. And thereafter, in terms of the cabinet decision, the government had regularized the service of all the OBB teachers, i.e. 4040 plus 7066 teachers in the year 2010 who were validly appointed. In the meanwhile, the proceedings of WPC 1457 of 2010 was disposed of by this court. Next, for the learned counsel has submitted that screening committees, 5 screening committees were constituted under the divisional commissioners of Upper Assam Division Lower Assam Division, North Assam Division, Hills and Barak Valley Division, and BTC area. And as per the screening committee reports, 136 numbers of teachers were found working till date and were recommended. This recommendation is for appointment.
Yes, madam. At that time, they were recommended by the subdivisional level selection committee, madam.
No, recommendation for what?
Appointment, madam.
Recommendation for appointment. The 250 teachers were recommended but discontinued the service. Age 706 numbers of teachers were not recommended, but they were found working till date. And 2664 numbers of teachers were not recommended and discontinued, their services were discontinued. And accordingly, all 11,756 numbers of teachers were screened. First of it is submitted that the petitioner did not participate in the said re-verification process. And accordingly, the petitioner is put under the illegally appointed teacher category. And she is not entitled to, claim a salary. As she was a legally appointed teacher. And on the said ground, this review petition has been filed for reviewing the order dated 29/2016 passed in WBC 4126 of 2012. Next slide. On a perusal of the order dated 29/2016, passed in WBC 4126 of 2012, the relevant observation of this court is quoted herein below, page 24. To page 25, tick mark. Next one. The it would also be relevant to quote the order dated 14/12/2007, passed by this court in WBC 6364 of 2007, give a dash, Srimati Dolly DOLLY, Hukan PHUKN, and 4 others versus the state of Assam and 4 others. Page 27 of the petition. From the conjoined reading of both the orders as extracted above, comment is observed that there is a categorical finding of this court in WBC in the order dated 29/2016 of this court that a decision was already taken by the Commissioner Secretary to the Government of Assam, Elementary Education Department to release the salary of the petitioner from the due date. And this court had also recorded that there was no dispute regarding appointment of the petitioner and her continuance in service. Therefore, in the considered opinion of the court, there was no requirement of the respondent. This petitioner first is respondent. The respondent to subject herself to a fresh scrutiny, as it is not the case of the Elementary Education Department that the earlier screening committee report, screening committee of the expert committee report concerning the petitioner was erroneous. Next, accordingly, as the petitioner was already subjected to an examination by the expert committee, and the departmental commissioner and secretary had already decided that the salary of the petitioner, the respondent herein be released from the due date. What is of the constitutional opinion that the petitioners have not, the applicants have not been able to, the review petitioners have not been able to make out a case for review of the order dated 29/2016 passed in WBC 4126 of 2012. So the court, next one, the court does not find that the order is vitiated by any other apparent on the face of record. It is not also the case of the petitioners that any new material has come out, which despite due diligence could not be produced before the court. Rather, the materials available point to the direction that the case of the petitioner was already examined and she was found working. So therefore, repetitive exercise to screen the legality of the appointment of the petitioner would not be sustainable. Next one, moreover, if the petitioners had any doubt as to the genuineness of the appointment of the respondent, they could have issued a specific notice on her to subject herself to a scrutiny, but the same was not done. Rather, it appears that the petitioners relied on their advertisement to be notice to participate in the selection process, and it was not indicated that, and the petitioner was, and the respondent was not put to notice that the earlier screening report would not be valid for her for determining her status. And accordingly, the non-appearance of the respondent before the subsequent screening committee cannot be faulted with. Cannot be faulted so for the purpose of determining this review petition. For determination of this review petition. Next will be the recipient. The court in exercise of this review jurisdiction has not met any has not determined any finding as with regard to the status of the respondent. Next, accordingly, the court does not find any merit in this review petition and the same is dismissed.
Obliged, Lordship.
So in my order, you will find two things. Number one, that I'm not giving any observation as to the status. And number two, if you have a doubt,
Yes, yes, ma'am.
still give a notice and subject her to scrutiny if you want to.
Yes, ma'am. Obliged, Lordship.
Yes. Item 3 and 4. 3 and 4. Yes.
May I please, as your lordship? Lord, the matter relates to, Lord, is a termination of the petitioner. Lord, after a long rendering service from the year 1998 till 2019, my lord. My lord, for the factual aspects, my lord, may be pleased to turn to, my lord, page 24, my lord.
'24.
Yes, my lord. Yes. Lord, this is an advertisement issued by the Lord Secretary of the special body of the governing body of the college, Lord, when the college was in the Lord deficit system of granting aid in the year 1998, and Lord, the present petitioner is concerned with the Lord post of lower division assistant. My lord, may be pleased to find non-teaching, non-sanctioned posts, my lord. Is at page, my lord, 24 LDA qualification higher secondary with typewriting, my lord. 2 numbers of posts, my lord, have been notified.
Yes.
Now, my lord, my qualification, my lord, may be pleased to find is at page 22 annexure 1.
Just tell me what is it.
My lord,
Just tell me what is it.
the facts of the case, my lord.
No, just tell me the qualification. I don't need to go to the
My
document.
qualification is higher secondary and computer diploma I had, my lord, at page 22 and 23, my lord. Now, my lord, and responding to this advertisement, my lord, I did apply, and accordingly, my lord, I was interviewed by the selection committee and my lord found to be eligible. And therefore, my lord, by resolution number, my lord, at page 27, annexure 5, is a resolution, my lord, pertaining to which a decision had been adopted for the purpose of my lord appointment. And the appointment order, my lord, may be pleased to find at page 30, annexure 6.
The resolution is at page.
Resolution is at page, my lord, 27, annexure 5. Meeting of the special body, Moirabari College on 12/7/1998. It is resolved today to appoint MD Mojibur Rahman petitioner, my lord, by following the departmental rules, by publishing in the newspaper, by holding the selection committee, by taking interview, and on found eligible, the selection committee by preparing a merit list who stood first.
And what is this special body?
Lord, actually at that relevant period of time, instead of Lord selection committee, they uses to term it Lord as a special body for the purpose of recruitment, Lord.
Okay.
My lord. And accordingly, my lord, responding to this resolution, my lord, the secretary and the principal of the college issued an appointment order in my favor, my lord, is at page 30, annexure 6. With reference to your application, interview selection and special bodies resolution number 4 dated 12/7/1998, you are hereby appointed as LDA of Moirabari College against the non-sanctioned post on a consolidated pay of ₹400 per month. Lord, admittedly, advertisement was floated for the purpose of a non-sanctioned post, Lord. It is not disputed. And accordingly, Lord, I joined at page 31, annexure 7, on the Lord on 24/7/8/1998.
Yes.
Then, my lord, the certain communications have been made, my lord, between the state respondents as well as the principal of the college for the purpose of, my lord, sanctioning or the giving me the benefit of a full-fledged government employee, my lord. My lord may be pleased to find one of the communication, my lord, is at page 32, annexure 8. Submission of particulars of post as per the proformas 1 and 2 of the Moirabari College. Your letter number dated so and so with reference to the, I have the honor to submit here with the field of proformas 1 and 2 of the Moirabari College. This is for favor of your kind information, and this is an Lord letter addressed from the principal to the Lord Director of the Higher Education. And in this proforma, proforma 2, the name of the petitioner, my lord, had also been reflected. Then, my lord, another letter has been communicated, my lord, by the principal of the college, addressed to the Director of Higher Education, my lord, is at page 36.
Just a moment, just a moment.
My lord.
Okay, yes.
Now, my lord may be pleased to find a very important communication, my lord, which has been made by the
principal to the director, my lord, is at page 39. To the director of higher education, from the principal prayer for sanction of the post of LDA, non-sanction. May I read over, my lord?
It's not required, we
My
understand.
lord. So now, my lord, this proposal has been made to the director for sanctioning of one post, my lord, for the purpose of accommodation of the present petitioner. Now, my lord, these are the communications which has been made. And not only the present petitioner, my lord, there are certain incumbents were working at that relevant period of time. From the particular shown in page 40, my lord, has also reflected the same, that how many posts are required to be sanctioned and what was the exact position of the number of existing sanctioned posts, requirement of the additional post category, everything has been given here, in this list. So, but my lord, the department, although this communication has been made, the department was sitting silent, my lord. Then the director of higher education wrote a letter to the commissioner, my lord, proposal for the creation of the post of LD assistant and the post of library assistant of Moiraburi College. Now, my lord, one aspect is there, my lord. Although the proposal for the lower division assistant and the post of library assistant of the Moiraburi College has been made by this letter, my lord, by the director to the commissioner, my lord, for my knowledge, my lord, we have come to know that the library post had been considered, but this LD assistant had not been considered by the government. Then, my lord, I approached before this honorable court, my lord, at page 43, annexure 13, my lord. Not a very long order, my lord. I can read over this order, my lord. Heard Mr. So-and-so learned counsel for the petitioner and pursuant to an advertisement for appointment to a non-sanctioned post. The petitioner applied in the Moiraburi College, Morigao, and was accordingly appointed as a lower division assistant on a consolidated pay of rupees 400 per month. Basically, with the help of this writ petition, the petitioner seeks sanction of the post of a lower division assistant in the said college and his appointment to the post, which he seeks to be so sanctioned.
It's okay, here just, this only says that the matter be examined.
Yes, my lord. In that view of the matter, it is hereby directed that shall examine the necessity of having a sanctioned post of lower division assistant. Yes, my lord. Now, my lord, although this order, there is a direction for, my lord, a necessity or required or not, my lord, but that exercise has also not been carried out. My lord. Then, my lord, I have again, my lord, made a representation, my lord, to the president and secretary of the governing body, application for appointment to a sanctioned post, and this has also not been considered. Then again, my lord, communication has been made at page 48, chapter 15, my lord, from the principal to the director. Same thing, my lord, nothing is there. Now, my lord, this is a letter from the joint secretary to the director of higher education regarding regularization of the present petitioner, my lord, as a junior assistant. This has at page 49, my lord, it has also not been considered, my lord. Then, my lord, finally, a representation has also been made to a, my lord, concerned minister, my lord, that has also been forwarded to the government, but it has not been taken into, my lord, accounts. Then, my lord, lastly, at page 51, annexure 18, is the similar thing, my lord, submission of report regarding regularization of the present petitioner to the, my lord, from the principal to the director. And this is a certificate that where I was working, my lord. This is to at page 52, my lord. And then, my lord, some of the similarly situated persons, my lord, has approached before this honorable court. What the government has done, my lord, they are contemplating to, my lord, recruit in these categories of institutions, my lord, by not considering the, my lord, similarly situated persons like, my lord, for the purpose of regularization. Then, in this petition, my lord, the petitioner was not a party there. But, my lord, just for the, my lord, so the similar cause, this is annexed, my lord. And lastly, this impugn order, my lord, at page 57, annexure 1, is the, my lord, cause of action for the present petition, my lord. By this letter, my lord, with reference to the subject cited above, I would like to state that pursuant to the GB resolution number so-and-so, you have engaged Mr. So-and-so against a non-sanctioned post in your college. Without the prior approval of this directorate, no such illegal engagement appointment should be encouraged. Moreover, does not have the requisite qualification as per the DH's notification dated 22/12/2016. There is no provision for the regularization of the service of a non-teaching staff appointed by the college authority against a non-sanctioned post in the Assam College Employees Provincialization Rules 2010. In the view of the above, you are instructed to remove and terminate MD so from his service immediately. Your compliance report should reach the undersigned by return on 8th March. Madam. Then we got I made a representation, for the for my arbitrary removal, before the Director of Higher Education is at page 59, wherein I have stated in detail as regards my position. Now, the law which is not applicable at that relevant period of time when the present petitioner was being appointed, if I am not wrong, the Assam College Employees Rules 1960, was governing at that relevant period of time. When this present petitioner was appointed. My lord, may be pleased to find the relevant rule is at page 448.
Yes.
My lord, the Assam Aided College Employees Rules 1960. My lord, may be pleased to find the method of recruitment is been given under Rule 4. How the selection board, is required to be constituted when given, and we are concerned with, the office assistant that is also being known as the junior assistant or LDA, at page 451. Sub rule 3, the governing body concerned shall, after due advertisement in at least 2 newspapers, make the appointment of the office assistant subject to the approval of the Director of Public Instruction Assam. This is relevant. The governing body concerned shall, after due advertisement in at least 2 newspapers, make the appointment of the office assistant subject to the approval of the Director of Public Instruction Assam. Now, admittedly, if you go by the records, there was an open advertisement has been made, and I stood, first in the category of the lower division assistant in the select list, and thereafter, I was appointed. But, there is one procedural lapse was there, from the record it transfers, which I have to admit and submit fairly before my lordships, that it reveals that, that the no approval from the Director of Higher Education was obtained at that relevant period of time. My case is that, it was not a case that the petitioner had been appointed on the, choose and on pick up and choose basis, I, responding to an open advertisement, along with me, some other post was also advertised, and incidentally, those posts got the sanction, or they were subsequently had been also been regularized. And but only the present petitioner, he has been left out. And the government, it was a conscious decision on the part of the government, from the date of my initial appointment, till the year 2019, there is no bar has been given to me that I should not work or there should be any restriction. I was allowed, and it was a constant communication was also going on, before the respondents for the purpose of either creation of a post or for the purpose of regularization of the petitioner. Now, suddenly, by this impugn order, the reason, which had been cited, my lordships has already gone through, they have cited 2 reasons, in the impugn order that does not have the requisite qualification as per the DHE's notification dated 22/12/2016. Now, I was appointed long back in the year 1998. So, obviously, this notification dated 22/12/2016 would not apply, in case of the petitioner. If it is a case of a recruitment, my lord, after the 2016, then obviously, my lord, this qualification criteria would have come into play, my lord. But, my lord, as I had been appointed long back in the year 1998, at that relevant period of time, my lord, higher secondary and computer diploma was the, my lord, basic requirement, my lord, qualification. So, my lord, it was an open advertisement, and after assessing my merits, my lord, the selection committee found me suitable and had been given me the appointment. So therefore, my lord, this reason which has been cited by the director that, my lord, 22/12/2016, the qualification criteria had been enhanced to graduate, my lord, by admittedly, after 22/12/2016, an incumbent is required to be graduate with other, my lord, qualification. But, my lord, my respectful submission, my lord, from my limited understanding, which I beg to make, my lord, is that this notification is not applicable for consideration of regularization or to make him a permanent employee is not required, my lord. Secondly, my lord, the director has said, my lord, without the approval of the directorate. Now, my lord, this situation, my lord, which was within the knowledge of the director from the year 1998 till 2019, that there was no approval had been obtained by the governing body or by the selection committee, my lord. That is a, my lord, procedural irregularities, my lord, from my limited understanding, which can also be given with post facto, my lord, approval can also be accorded for the purpose of considering the, my lord, other similarly situated person which they have done. My lord, this present petitioner can also be, my lord, accommodated in such a manner. Now, my lord, the issue of regularization, my lord, which I have raised in my writ petition, my lord, is that, my lord, if a sanction post is not there, my lord, then the government can, my lord, regularize such type of incumbents, my lord, by creating a post, my lord, for the purpose of this present incumbent, my lord. A personal post can also be created for the purpose of regularizing the present petitioner, my lord. My lord, I have, my lord, gone through the some of the judgments, my lord, which my lordship is well aware, my lord, in the Nihal Singh, my lord, the case which has been arising out of, my lord, Uma Devi's floating from Uma Devi, ML Kesra and other cases, my lord. In the Nihal Singh's case, my lordship in paragraph 20 is very vital, my lord, wherein the my lord, I have made a compendium, my lord, regarding this regularization subject, my lord. My lordship, may you please to take up, my lord. My lord, in this compendium, I beg to draw your lordship's kind perusal, my lord, is at page 9. Is at page 9, my lord, 2013-14 SCC, page 65, Nihal Singh and others versus the state of Punjab and others. Now, my lord, straightway, my lordship may be kindly come, my lord, to page number 18, my lord, paragraph 20. Page, my lordship got it, my lord, page 18,
Yes.
my lord. Page
Just-
18, yes, my lord, paragraph
Just-
20,
Just a moment.
my lord.
Para 20.
Para 20 at page 18, my lord. I have made manual pagination, my lord, the top of the,
Yes.
my lord. Paragraph 20, my lord. But we do not see any justification for the state to take a defense that after permitting the utilization of the services of a large number of people, like the appellants for decades, to say that there are no sanctioned posts to absorb the,
May I just,
My-
I'm stopping you for a moment.
my lord.
You see, in this, the background facts of this Nihal Singh
My lord.
was that under the, in Punjab at that point of time, there was disturbance, and in the Punjab Police Manual, there is a provision of appointing special police officers.
my lord,
Similar provision is there in the state of Assam also.
my lord.
Assam Police Manual does have a
Yes, yes, yes.
chapter for special police officers. Now, these people were recruited in a valid way
my lord.
to the post of special police officers.
Right.
Their services were extracted
Yes, yes,
and then they were not absorbed.
my lord.
So because that post existed and the recruitment took place in those posts. There's no
Ah.
doubt about that.
Yes, my lord, I have gone through the judgment, my
So
lord.
therefore, you see,
Why?
here is a case where the post does not exist.
My lord.
It's a non-sanctioned post and the approval was not taken. So
Yes.
there's a, you have to overcome that, what you call that hurdle.
My lord. No, my lord, in that cases, my lord, the concept of regularization, my lord, is very clear, my lord, in paragraph 53 of the Uma Devi, my lord, has
Devi.
also held that, my lord, their continuous 10-year service, my lord, in a sanctioned post. My lord, even if my case goes against me, my lord, the law is well settled, my lord. Even for the purpose of regularization, my lord, paragraph 53 is the only, my lord, only the legal provision which can come into, my lord, rescue. I have also made that, my lord, paragraph 53 as a part of this manual, my lord. My lord. So now, my lord, if my in paragraph 20, my lord, just for a moment, my lord, I beg to draw your lordship's attention, my lord. But we do not see any justification for the state to take a defense that after permitting the utilization of the service of a large number of people like the appellants for decades, to say that there are no sanctioned posts to absorb the appellants. Sanctioned posts do not fall from heaven. The state has to create them by a conscious choice on the basis of some rational assessment of the need. So now, my lord, if my lord, the present case is taken up, my lord, then the situation is exactly the same, my lord. The state is saying, my lord, that as my appointment is against a non-sanctioned post, and they have utilized my service, my lord, may kindly appreciate from the year 1998 till, my lord, 2019, they have consciously, my lord, adopted a policy to extract my service, my lord. Extract my service as a, my lord, lower division assistant, and I have also fully cooperated, my lord, and had a, my lord, legitimate expectation, my lord, by way of their act of the respondent, that I would be regularized, or, my lord, my service would be made permanent in due course of time, as it had been done, my lord, along with the some other similarly situated incumbents who were, my lord, appointed with the similar advertisement. So, my lord, therefore, this paragraph 20, my lord, if I am not, my lord, wrongly understood, can be a cause for rescue of the present petitioner also, my lord. That as they have said, my lord, that that there are no sanctioned posts. Admittedly, my lord, I was appointed against a non-sanctioned post to absorb the appellants. They can say, my lord, that we cannot absorb now, as there is a, my lord, no sanctioned post was there. But, my lord, my respectful submission, my lord, to that extent is that, my lord, as they have consciously, my lord, taken my service for the more than, my lord, from 98 to 1921 years. My lord, so therefore, at the fag end of my service, my lord, kindly appreciate, my lord, now they have decided to throw me out from the job. My lord, now I am around 45, 46 years, my lord. Now I cannot go for any other employment. They could have done or take this drastic action, my lord, long back, that as you are appointed against a non-sanctioned post. So therefore, my lord, there is no scope for your regularization or, my lord, something like that. But after making so many, my lord, conscious communications between the state respondent from the principal to the government level, my lord, they have not done. And secondly, my lord, the direction which has been issued by this honorable court, my lord, in a writ petition, my lord, although it is not very, my lord, in the nature of a mandamus, my lord, if I just for a moment, my lord, if I beg to draw your lordship's kind attention to the order, my lord, the last
No,
part.
only, Mr. Bhuya,
Why?
only at best,
Why?
there's a decision of this court in that writ appeal 45, that is Upen Das.
Open this, yes, my lord.
I think at best we can only direct the state to take a call on your entitlement to the benefit flowing from Upen Das.
My lord.
But there's no other way to
Help.
give any relief
My
You
lord,
see, the number one, Uma Devi is there,
my lord.
no doubt about it. But the other factor is that the prior approval not being there,
My lord.
there's no way to regularize it.
My lord, sometime we, in such a situation, my lord, after such a long tenure of service, my lord, government can go for post facto approval also, my lord.
No, for that we can't issue a mandamus.
Yes, yes, my lord.
The-
That is
the-
within their way.
This is within their domain.
My lord. My lord, I have also annexed this Upenda's case in
Is
part
there?
of this compendium. my lord.
Okay,
Yes,
okay,
yes, my lord.
okay.
My lord, may be pleased to find the Upenda starts from, my lord, at page 69,
69, okay.
my lord. And the operative part, my lord.
That operative I remember because
My lord, my lord.
used in many cases.
Yes, many cases, my
Upenda's.
lord, this has now been referred, my lord. Now, my lord,
Yes.
my friends, my lord, submission.
Yes.
Made
Mr.
please, your
Gogoi,
lordship. Lordship. But my
In
friend-
in this Nihal Singh,
My lord.
there's one more factor. Which I did not address. You see, here what had happened was in Nihal Singh, the person was appointed. I think he, if I remember correctly, he was a ex-army man.
Ex-army men,
My
they are recruited in the special police. force,
Special
Lord.
police
My lord,
force.
yes, yes, my lord.
And then what had happened was that his service was given to the bank. And there was a requirement that the bank would pay him.
Lordship.
And therefore, in the defense, the state took a plea that, well, his service was with the bank, so we did not regularize him.
Yes, yes. No liability of the state.
No liability of the
My
state.
lord.
That is what
Yes.
the
State defense, my lord.
My lord sir rightly pointed out about Nihal Singh Lordship. Otherwise, Uma Devi's law is already constitutional bench settled the position Lordship. The exception carved out in paragraph 52 of Uma Devi case is Lordship, not applicable to the petitioner's case. Because he is engaged by the college authority Lordship, a purely a temporary basis and non-sanctioned post Lordship. And my lord may kindly peruse page 45 Lordship, kindly for a moment page 45 Lordship. Page 45 is the continuation of the annexure 13 Lordship. It is a
Mr. Govind, before that, I just wanted, sir, I did not, in fact, it never occurred to me earlier.
Yes.
Now you see, what according to you is a sanctioned post and what is a non-sanctioned post?
Lordship.
What is the difference between two?
Non-sanctioned post, Lordship is a non-existence post, which was the post which is not in the statute book itself, even Lordship, that post was not created by the government, Lordship.
Okay,
Lordship,
so therefore, if the college still
Lordship,
knowing their limitations,
Lordship,
they engage someone
Lordship,
as in a non-sanctioned post,
Lordship.
then why the state will issue a direction to remove
Lordship,
him?
it is a internal arrangement of the college.
No,
authority,
that's why I'm saying.
Lordship,
Why
because
does
Lordship,
the,
otherwise, that direction, issuance of direction, reason is there, Lordship. We have time and again, Lordship, issued notification, Lordship, regarding not to engage any non-sanctioned teachers or non-sanctioned, Lordship, a non-teaching staff, Lordship. Even then also, Lordship, the college authority has employed an internal arrangement, they have engaged the
no,
persons.
you see, there are reasons for it.
Lordship,
Let us assume
Lordship,
that I am more lazy than others.
Lordship,
I'll just give you an example.
Lordship.
May not be appropriate, but
That
it's just
cannot
an
be, Lordship.
example. Say
Even Lordship,
I'm more
Lordship
lazy than others.
judgment, Lordship judgment, every day evening we have got it, Lordship.
No, not that.
I'm saying that, Lordship.
No, not
Even
that.
Lordship cannot say
I'm-
that Lordship are lazy person, Lordship.
No, I'm just saying, it's an example.
Lordship.
It's an example.
Lordship.
I don't say it's a fact. I say this is give an example.
Lordship.
And therefore, what happens is that in my chamber,
Lordship.
I engage one staff from my own. The government doesn't pay for it.
Lordship.
I engage him because he gives me everything ready, my pencil, pen, everything he
Lordship.
gives ready, and then it makes me my life easier.
Lordship.
So he's a staff engaged by me purely through my own resources, and I engage him.
Lordship.
Now I understand the state in your case, in this case, the state telling that, well, his payment I will not make.
Lordship.
But why is a direction issued to disengage him?
Lordship. It is
Supposing
a-
I have a person, why
Lord.
should someone say I disengage him? I am paying from my own resources.
Lordship.
Because our basic reason is that, Lordship, despite our communication, repeated communication, not to engage the non-sanctioned teachers, even non-sanctioned non-teaching staff, Lordship. After that, also college authority has appoint them on a temporary basis, the internal arrangement of the college, they have paid from the internal source and from the college, Lordship. No way connected to the government, Lordship. After that particular person's, Lordship, approves the honorable court for other thing directorate for, Lordship, seeking regulation, Lordship. To prevent that purpose, Lordship, we have issued the notice.
Okay.
That is the reason, Lordship. And then my lord may kindly peruse page 45, Lordship. Earlier, honorable, my brother's client approves the honorable court's, Lordship, and the findings of the honorable court, page 45. My lord may kindly peruse. If Lordship permit, then I can read, Lordship, first paragraph, Lordship. Pursuant,
Yes, last line in that first paragraph, apart from that petitioner
Lordship,
being contractual.
petition being a contractual member cannot be absorbed against a sanction post, even if such post is sanctioned, Lordship. This is the ultimate finding of the honorable court's, Lordship, and it is attained finality, Lordship. Now we cannot open this, Lordship. And even, Lordship, government has created the sanction post, Lordship, as per the last two paragraph, Lordship. Then it will go by the, Lordship, provisions of the 2010 rules, Lordship. 2010 rules, there is a statutory prescription is there, Lordship, how we have to appoint the persons, Lordship. 2010 rules, Lordship.
It's a graduate now.
Lordship.
It's a graduate now.
Graduate, not only graduate, Lordship, there are mode of appointment also there, Lordship.
Oh, acha.
Mode of appointment is there, Lordship. Method of recruitment in page 497, Lordship. 497, Lordship, 497. Rule 5 is, Lordship, method of recruitment, Lordship, and petitioner's case is applicable in next page, Lordship. 5, sub-rule 5, Lordship. The post of lower division assistant, laboratory assistant, library bearer shall be filled up by the direct recruitment from the and from the laboratory bearer, library bearer get for, Lordship, having qualifying as prescribed ratio 25:20, 75:25. 25 goes from, Lordship, promotion, Lordship. 75 is a direct recruitment, Lordship. 25 from the laboratory bearer, library bearer, Lordship. Get for we have recruited, Lordship, and other things are direct recruitment, Lordship.
No, but then if it is only one post, the 75-25 ratio will not be followed.
Not followed, Lordship. At least 3 posts is there in every college. 3 posts or 2 posts is there, Lordship. In every college, Lordship. And regarding that particular observation of the honorable court's, Lordship, till today government has not created the post, Lordship, because there is a not necessary of another extra post, Lordship, to the college. So we have not created post, Lordship. That is on, Lordship. And we have also categorically stated in our affidavit, Lordship. And regarding regulation power, honorable court already decided in 27/2010, Lordship.
But this benefit of Open Das,
Open Das, Lordship, it is a casual employee, Lordship. It is a decision by the cabinet, Lordship. Government decision is there, Lordship. Open Das is not applicable here, Lordship.
it will not be applicable.
Not applicable here because it's not a casual employee of the government, Lordship. It's a temporary engagement by the college, internal arrangement of the college, Lordship, against a non-existence post, Lordship. The law laid down by the honorable court in Open Das case, Lordship, the guidelines and issues framed, that will not applicable here, Lordship. That is, Lordship, purely a casual employee, and over and above, Lordship, there is a cabinet decision is there, Lordship. And we have filed affidavit, Lordship, paragraph 6, 8, 9, 10, and 13, Lordship, we have categorically stated. My lord may kindly note it. Paragraph 6, 8.
Just now.
Lordship.
Para,
Lordship, paragraph 6, 8, 9, 10, and 13, Lordship.
okay.
Lordship, even recently, Lordship, Honorable Apex Court on 23rd or 20 March 24, Lordship. Lordship, I will keep the date, Lordship. Decided that should open it.
No, just give me the name. I may have it.
Lordship, in the live law, Lordship,
Mhm.
State of Gujarat and others versus Lordship, RJ Pathan and others, Lordship.
RJ Pathan.
RJ Pathan and others, Lordship.
State of Gujarat was RJ Pathan.
Lordship,
Yes, I have it.
Lordship. Lordship.
No, if I remember correctly, this RJ Pathan case
Lordship, they
was for against the earthquake,
temporary appointment.
temporary
is
appointment for
temporary
earthquake
appointment.
relief.
Then also, Lordship, Honorable Apex Court says that, Lordship, you cannot regularize them, Lordship.
But in this case,
Lordship, in this case, Honorable Gujarat High Court judgment is that, Lordship, you create a supernumerary post and adjust them. Then Honorable Apex Court finding is that, Lordship, you cannot.
where is that?
Lordship, it's a head note says that, Lordship, I mean, I can say, High Court directed the state to consider the cases of some temporary employees for regularization sympathetically and if necessary by creating supernumerary posts. Such a direction is wholly without the jurisdiction, Lordship. No such order of absorption and or regularization, even if required for creating supernumerary posts and not to treat the same as a precedent, could have been passed by the High Court in exercising the power under Article 226 of the Constitution. Paragraph 6 and 10, Lordship, Honorable Apex Court categorically finding. Categorical finding is there, Lordship. And in that particular case, Honorable Apex Court relied the, Lordship, the constitutional judgment of Umar Devi's, Lordship. It is in paragraph 8, Lordship.
Okay.
Even, Lordship, last week also one judgment is come, Lordship. But, Lordship, I am not just find out, Lordship. Same benches delivered the judgment, Lordship.
Okay.
Last week, Lordship.
I'm not that update.
Lordship said updated. We have learned from Lordship.
No,
Yes.
you have done well.
Even Lordship says, even we are not finding the citation, Lordship, in the latest case law, Lordship has given us that citation, Lordship.
Yes, Mr. Mukhtar.
Oblige, Lordship.
I'm explaining for the respondent 4 and 5 ballot. Here in this case, my lord, although we gave advertisement ballot for absorption ballot, and thereafter we thought that my lord that on humanitarian ground my lord, his case will be considered by the authority. On several occasions we have written my lord. It may not be, it is not as per law. And thereafter, my lord, the director has issued order, a letter to us on 17/7/19 my lord, to remove him, my lord. Accordingly, we have removed on the next day, my lord, as per direction of the higher authority, my lord. We have to comply, my lord. We simply obey the order of the higher authority, my lord. Although we have sympathy for him, my lord, we cannot help him, my lord.
No, if you wanted, sympathy could have been translated into empathy by
Now we have
giving,
written
giving him,
on many occasions, my lord.
giving him salary from your own resources. That empathy could have been shown.
Some, a small amount has been paid, my lord, but definitely there is not sufficient for him, my lord. College shows some pretense, my lord, definitely pretense, my lord.
Then Mr. Bhuyan, we
My
have to
lord.
give you a right of appeal.
I have to inform the client, my lord. My lord, one thing, my lord, what my respected senior friends have submitted, my lord, that my lordship is well aware regarding the concept of provincialization. My lord. My lord, in all these categories of venture institutions, my lord, which the government has recently taken up for the purpose of provincialization, there is no fair and transparent selection process. My lordship is well aware, my lord, that just the pick and choose policies appointments were there. Now, my lord, the state, by of an statute, my lord, has enacted a policy for the purpose of provincialization of these employees. And accordingly, my lord, post has also been created, and they have been given the full-fledged benefit of the government employees. Now, my lord, in this type of cases, my lord, wherein, my lord, at that relevant period of time, when, my lord, the rule of 1969 was governing, my lord, the condition was that there should be an open advertisement, and basing on that advertisement, my lord's recruitment can be carried out. Now, my lord, only exception in my case is that the prior approval before the appointment, my lord, of the director was not there, was not taken by the my lord, the governing body or the selection committee of the college. But, my lord, along with me, some other similarly situated incumbents who were appointed, my lord, at that relevant period of time by adopting this similar mode. Of late, my lord, subsequently their post has also been sanctioned, and they have also been made a full-fledged employee under the, my lord, rule. Now, my lord, the rule which my learned friend has relied on of the 2010 rules, my lord, that is also not applicable in case of the petitioner, my lord. As because, my lord, my selection and appointment was way back in the year 1998. Now, I cannot be subjected to a rule which has been made for 2010. Yes, my lord, if an open advertisement is made for in case of the 2010 rule recruitment process, my lord, then obviously, my lord, I have to qualify myself to offer my candidature responding to the rule and the qualification. But here is a case, my lord, that is also not applicable in my case, my lord. So, my lord, may kindly appreciate, my lord, a person, my lord, who has given his, my lord, whole life. Now I have to say, my lord, whole life, because if I cannot be accommodated in this post, my lord, I have children, I have a family, my lord, which I was somehow managing with this, my lord, service, my lord. Now, just for a procedural lapse, my lord, I have been thrown out from the service, my lord. That will be a totally an inhuman and against the policy of the state, my lord. By my lord, considering the policy of the on humanitarian ground also, my lord, the
No,
government has,
yeah, but
my
you
lord,
see,
my lord.
there will be a difficulty to accept your submission, because if there is a if there is a recruitment rules which is required to be followed,
My lord. My lord.
we can't say that an exception be carved out for two reasons. Number one, the qualifications have changed.
At present, my lord.
At present, the qualifications have changed.
Change, yes, my lord.
So you have to, even if you were there, and let us assume that you are entitled to the regularization right now,
My lord.
even then the qualifications have changed. And for that, I think there is a judgment of this court that higher qualification, if it is prescribed, that has to be accepted.
My lord, for the purpose of regularization, my lord, may kindly appreciate a situation, my lord. What the state has done in case of those provincialized employees, my lord, if somebody is not qualified, they are made as a tutor, and they have given an, my lord, additional time period of 5 years to qualify themselves to become a full-fledged teacher. Now, my lord, exactly the policy of the state cannot be, my lord, discriminatory. Here is a case, my lord, wherein the present petitioner was appointed way back in the year 1998, when I was fully qualified in terms of that rule, my lord. My lord, the state is saying that the rule is applicable for me. If, my lord, the half of the rule is applicable for me, my lord, then the full is also required to be applicable to me, my lord. Now, they have said that there was no approval from the director was obtained. That is a part of the requirement of the rule, my lord. Now, another part of the requirement of the rule is that I was qualified. And it was a conscious decision on the part of the state, my lord, that I have been allowed to continue for more than 21 years, my lord. Kindly appreciate the situation, my lord. A person, my lord, a human being, where he will go at this moment, my lord, if I have been thrown out. So therefore, my lord, this concept, the state is very, my lord, as a welfare state, my lord, they are always thinking for the welfare of these categories of people, my lord. That those person who has rendered, my lord, long pending services without any honorarium or benefit, they should be at least given some, my lord, benefit at the fag end of their service, my lord. That's why this concept of provincialization, my lord, and the other policies of regularization, my lord. My lord, as my initial appointment, my lord, with all respect, what I respectfully beg to submit before my lordship is that, yes, my lord, there are certain irregularities in my case, my lord, that the one irregularity is that non-sanctioned post, my lord. And secondly, my lord, is the approval of the director was not there. For those, my lord, those irregularities, government can always have the power and discretion to regularize me, my lord, by overcoming all these things, my lord. That is my respectful submission, my lord. And my lordship may kindly appreciate the tenure of my long pending service, my lord.
My lord, I have got the judgment. So it is delivered on February 8, 2023, lordship. The Vibhuti Shankar Pandey versus State of Madhya Pradesh, lordship.
February
8 February 2023, lordship. Vibhuti Shankar Pandey versus State of Madhya Pradesh, lordship. Here, paragraph 3, lordship, 3 and 4, lordship. Small judgment, lordship.
just a moment, we'll find out.
Lordship.
The previous judgment you referred to RJ Pathan
Lordship.
is already reported in SCC
Lordship.
2022 5 SCC 394.
It2. My lordship submission was also there, lordship. Lordship always give us the up-to-date citation, lordship. I always
sir,
find the lordship. Just we have indicated the case number and name, lordship says give us the lordship citation.
How do you spell Vibhuti? BI or VI?
Lordship. VIBHUTI.
Okay.
Shankar lordship Pandey.
Okay.
Lordship. Honorable Court considered the twin condition which was prescribed by the lordship, the constitutional bench judgment, lordship.
Okay.
Lordship.
The last scope also goes.
My lord,
The last scope also goes with this. Vibhuti.
my lord. My learned friend is always equipped with up-to-date arms, my lord. I was afraid of him, my lord. But the case of the petitioner, my lord, is very limited, my lord. Otherwise, because
No, it's okay. The
My
scope is,
my lord.
I have to be bound by this. Okay. Heard Mr. A.R. Bhuya, the counsel for the petitioner. Also heard Mr. K. Gogoi, the standing counsel for the Higher Education Department, appearing for respondent numbers 1 and 2.
Lordship.
Finance,
Lordship, I am for 1 and 3, lordship.
1 and 3, 1
Who
and
is
3.
for finance?
2,
Okay,
and Mr. A. Shalia Lanet, standing counsel for the Finance Department, appearing for respondent number 2. As well as Mr. S. Mukhtar, the counsel appearing for respondent number 4 and 5. I, the governing body, and the principal of Moirabari College, Moirabari College. The in brief, the case of the petitioner is that pursuant to an advertisement dated 22/3/1998 issued by the secretary, special body of Moirabari College for recruitment to various posts, including 2 posts of LDA, the lower division assistant within bracket LDA for short, the petitioner had offered his candidature and by a call letter dated 6/6/1998, the petitioner was allowed to attend, was asked to attend the college on 14/6/1998 for interview along with the documents. Full stop. As per resolution number 4, dated 12/7/1998 by the taken in the meeting of the special body, Moirabari College, the petitioner who had stood first was selected. And thereafter, by an appointment order dated 5/8/1998, the petitioner was appointed as LDA of Moirabari College against non-sanctioned post in a consolidated pay of ₹400 per month from the date of joining. The petitioner joined service on 7/8/1998. Full stop. The authorities of the Moirabari College had submitted various request letters to the competent authorities in the higher education department for regularization / provincialization of the post of the petitioner. But those representations are projected to have not been responded to. Full stop. Subsequently, by a letter dated 2/5/2008, the director higher education Assam had recommended had written a letter, had recommended creation of a post of LDA and post of library assistant in Moirabari College, comma, addressed to the Commissioner Secretary of the Government of Assam, Education within bracket higher bracket post department. Full stop. As nothing materialized, comma, the petitioner approached this court by filing WPC 3827 of 2010. And this court by order dated 2/7/2010 directed the Commissioner Secretary to the Government of Assam, Higher Education Department to examine whether the petitioner's college needs a post of LDA and a post can be sanctioned. And to do the needful in accordance with law. Full stop. The petitioner as well as the college authorities again represented the cause of the petitioner. Next paragraph. Thereafter, the Director Higher Education Assad by the imperial letter dated 7/3/2019 observed that the petitioner did not have the requisite qualification as per notification dated 22/12/2016 by the Director of Higher Education and the principal of Moirabari College was also informed that there was no provision for regularization of service of non-teaching staff appointed by the college authority against non-sanctioned post in the Assam College employees within bracket provincialization bracket closed rules, comma 2010. Accordingly, the principal was directed to remove the petitioner from service. So accordingly, by a letter dated 8/3/2019, the petitioner was removed from service by the college authorities. Accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the impugn orders dated 7/3/2019 and 10/19 issued by the Director of Higher Education Assam, as well as order dated 8/3/2019 by the principal of Moirabari College They were removing the petitioner from the post of junior assistant. Petitioner is also paid for constitutional reliefs. To direct the respondent authorities to sanction the post of junior assistant of the LDA and to adjust the petitioner in the vacant post of LDA, which with effect from 31/12/2014. Next one, the learned counsel for the petitioner has submitted that the petitioner has rendered how many years? 26 years.
Why not, from 98 to 19, it is 2 plus 19, 21 years.
21 years. Rendered 21 years of service. And he has almost spent a major part of his life to serve the Moravali College. And therefore, the termination and removal of service of the petitioner was harsh, which affected his livelihood as well as has caused great hardship to his family. It is submitted that the authorities would always have power to create a supernumerary post or to sanction a post of LDA and to adjust the petitioner in the said post. First, it is also submitted that the only irregularity in the issuance of appointment order to the petitioner was that the college authorities did not take prior permission from the Director of Higher Education, Assam, but they have otherwise complied with the requirement of Rule 4 within bracket 3 of the Assam Edit College Employees Rules, 1960, by issuing advertisement for, and the petitioner was selected pursuant to advertisement process, to a regular recruitment process initiated through an advertisement. It is submitted that the petitioner has been arbitrarily ousted from service, whereas several other persons were similarly appointed had got their service regularized by the government. First, it is submitted that since 1998 till the Imperial order was passed, the several representations were submitted by the petitioner as well as the college authorities, and therefore the Higher Education Department was aware that the petitioner was rendering service since the year 1998. First, it is also submitted that as the petitioner joined service in the year 1998, subsequent rules and notification of 2010 and thereafter could not have been applied on the petitioner to deny his regularization of service. First, in support of his submissions, the Learned Counsel for the petitioner has relied on the case of Nihal Singh and others versus State of Punjab and others, within bracket 2013, bracket was 14 SCC 65, Secretary, State of Karnataka and others versus Umadevi within bracket 3, bracket was and others, within bracket 2006, bracket was 4 SCC, page 1, State of Assam versus Upen Das, within bracket 2017, bracket close 4 GLR 493. And Sudarshan SUDAR SANAN A full stop and another was the state of Kerala and others. 2019 SCC online Kerala KER 1736. Next one. The yes, sir.
I'm sorry interfering. One submission I have not left out, that the termination was without hearing the petitioner, without giving any opportunity of hearing. It is just a
Okay.
mistake.
Just add before that, before citation, we submitted that the petitioner was not put to notice and was not heard before terminating his service. Next one. The learned counsel for respondent number 4 and 5 has supported the claim of the petitioner for his regularization and for regularization of his service. And we submitted that as the petitioner had rendered long service to the college, the college authorities have all sympathies with the petitioner, Mr. Howard, as they were directed by the Director of Elementary Education Assam by the imperial letter dated 7/3/2019. The college authorities had no option but to terminate the service of the petitioner by issuing the order dated 8/3/2019. Next, per contract, the learned standing also for the Higher Education Department has submitted that the recruitment that the post to which the petitioner was appointed was a non-sanctioned post, and therefore the government in the Higher Education Department is not bound to regularize the service of the petitioner was appointed despite repeated directions not to engage any person in the non-sanctioned posts. So it is submitted that even if a post is created and obligor sanctioned, the respondent authorities would be bound to follow the procedure prescribed under the Assam College Employees within bracket provincialization bracket close rules, 2010, which under which the prescription for recruitment for the post of LD and library assistant would be as per sub-rule 5 of rule 5 of the set 2010 rules. which required that the posts should be filled up by direct recruitment from the and from the laboratory bearers oblique library bearers oblique grade 4 having qualification as prescribed under the ratio of 75:25. So it is submitted that under the where is that 2016 rules? 2016 rules you say?
2010 rules, Lordship.
2010 rules.
10 rules, Lordship.
This has been amended.
496, Lordship. Page.
No, this qualification has been amended.
Qualification office memorandum is there, Lordship.
No, qualification is made amended by the notification of 2016, my lord. That, my lord, may be pleased to find at the impugn order itself, my lord. At page
Page 57, Lordship.
at page 57, that memorandum is given 22/12/2016. Page 57 in the impugn.
Oh, okay. No, not under the rules. Here, the qualification as per notification number DHE oblique capital C oblique Miss MISC oblique 341 oblique 2016 oblique 39 dated 22/12/2016 within page 57. And according to the minimum qualification for appointment is prescribed as graduate in any discipline. First off, it is submitted that the regularization cannot be a mode of recruitment insofar as the government is concerned. And it is further submitted that the state is bound by the ratio laid down in the case of Uma Devi within bracket Supra. First off, it is also submitted that as per the judgment of the Supreme Court of India in the case of Vibhuti, VIBHUTI, Shankar, SHANKAR, Pandey, PNDY versus State of Madhya Pradesh and others. Within bracket 2023, bracket close 0, Supreme, within bracket SC, bracket close 96. It has been laid down that the initial appointment must have been done by the competent authority and that the person appointed must have the minimum qualification prescribed for the said post. And as the applicant in the said case lacked in both the qualifications oblique prescription, comma, the Supreme Court of India had approved the order passed by the division bench of Madhya Pradesh High Court, comma, reversing benefit of upholding the reversal of benefit of regularization. So it is submitted that the said authority, this said judgment is also an authority on the point Do that last time. Okay. It is. By referring to the case of State of Gujarat versus R.J. Pathan, within bracket 2022, bracket close 5 SCC 394. Comment is submitted that the said decision is an authority on the point that in exercise of power under Article 226 of the Constitution of India, the court would not have power to direct the state government to create supernumerary posts. And to absorb a particular candidate in the said service by regularizing their services. It is submitted that in both the cases cited by him, the Supreme Court of India had relied on the decision of Uma Devi within the Supra. Next paragraph. In the present case in hand, it is seen that the petitioner has not been able to show that prior to issuance of the employment advertisement by the respondent number 4 and 5, prior approval of the Director of Higher Education was taken. Moreover, the respondent numbers 4 and 5 have also not been able to show that they had the prior approval of the competent authority before issuing an employment advertisement for filling of non-sanctioned posts of LDA. Therefore, it appears that the requirement of sub-rule 3 or rule 4 of the Assam Elite College Employees Rules, 1960 has not been followed. Therefore, the court could have to accept the submission made by the Learned Standing Council for the Higher Education Department that regularization cannot be a mode of appointment. And if one needs an authority on the point, the decision of the Supreme Court of India in the case of Uma Devi within bracket Supra may be referred to. Next paragraph. one of the submissions made by the learned counsel for the petitioner is that the subsequent enhancement of educational qualification which has been prescribed as the minimum qualification for appointment of post of LDA could not have been applied to the petitioner. First of in the said connection, the court is of the considered opinion that if by way of regularization, by way of regularization, the when the service of the petitioner cannot be regularized, the petitioner would have to fulfill the criteria which is prescribed at the present to seek employment in the Moravari College as LDA. First one. Although the submission made by the counsel for the petitioner that in several cases where services of large number of people were regularized, the government had granted time to the said employees to acquire higher qualification. First of all, however, the said principle cannot be applied in the present case, as there was no decision by the government to regularize the service of the petitioner or other similarly situated persons. First of therefore, the appointment of the petitioner must be in accordance with the prescribed rules. First of insofar as the next para, insofar as the case of Nihal Singh is concerned, the said ratio would not apply in the present case in hand because of the peculiar facts in which the case of Nihal Singh was decided by the Supreme Court of India. First of all, in the said case, it was permissible for the prescribed authority to appoint persons as special police officers, because at that point of time, the state of Punjab was in a grip of certain subversive activities by a class of persons. And on appointment, the apparent therein was allowed to work as guard in a bank, and the salary of such person was given by the bank. And therefore, when the issue of regularization arose, the state of Punjab had tried to wash off its hands by taking a plea that the petitioner was placed in service with the bank, and under the said circumstances, it was held that the state had extracted service from the appellant, and therefore he was entitled to regularization. Full stop. Therefore, on the facts of the present case, the case of cited case of Nihal Singh is distinguishable. Next, insofar as the case of Umadevi within bracket Supra is concerned, the ratio is called down in paragraph 53 of the said decision. Full stop. In the present case in hand, the court has not been able to accept the submission made by the learned counsel for the petitioner that his service was irregular because the Moirabadi College, while appointing the petitioner in a non-sanctioned post, did not take the prior approval of the competent authority as was required under sub-rule 3 of rule 4 of the 1960 rules. And therefore, the petitioner is already not required. So therefore, the case of Umadevi does not help the cause of the petitioner. Next, insofar as the case of Upen Das is concerned, the state government had taken a cabinet decision to regularize the service of the master roll workers, and it is under the said context that this court, while referring to a case of Umadevi within bracket Supra, had held that the issue of regularization was out of question. The issue of regularization service of the respondent therein was out of question, and therefore, following the ratio laid down the case of State of Punjab versus Jagjit Singh within bracket 2017, bracket was 1 SCC 148. A direction was issued to the state to pay minimum pay scale to the master roll workers. So they said, therefore, the said ratio cannot be applied in the present case in hand. Next, insofar as the case of Sudarsanan, SUDARSANAN within bracket Supra. Although in the said case, a direction was issued to interfere with the decision of the tribunal and direct regularization of service of the petitioners therein. But in view of the subsequent decision of the Supreme Court of India in the case of R.J. Pathan and others within bracket Supra. The court is of the constitutional opinion that the decision rendered because the constitution that with utmost respect to the decision of the Kerala High Court in the case of Sudarshan and K, the said ratio would not have persuasive value. In light of decision of the Supreme Court of India in the case of R.J. Pathan within brackets and others Supra. Next, in view of the discussions above, the court is of the constitutional opinion that the not that before that you write one more line. Next, the council for the standing council for the higher education department has referred to the order dated 2/7/2010 passed in WBC 3827 of 2010. He pointed that in the said decision, it was made clear that an observation was made to the following effect: ... within inverted commas. Then this apart comma, the petitioner comma, being a contractual employee comma, cannot be absorbed against a sanctioned post, even if such a post is sanctioned. Full stop. ... inverted comma closed. So accordingly, they submitted that. Accordingly, the court is inclined to accept the submission of the learned standing council for the higher education department that even if a sanction is made to the post of LDA, sanction made for the post of LDA, comma, the right of the petitioner has already been determined in the order dated 2/7/2010, passed in WBC 3827 or 2010, which is attained finally. Next, accordingly, the court is of the constitutional opinion that the petitioner is not entitled to any of the reliefs as prayed for. And therefore, the writ petition stands dismissed. The parties are left to bear their own cost. Next paragraph, just a minute. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner has become overaged for any other employment. If that be so, comma, it would be open to the petitioner when he applies for any post, comma, he would approach the competent authorities with a representation for relaxation of his age. And if such a prayer is made, comma, it is expected that the concerned competent authority shall take a decision thereon at an earliest, so that the petitioner is not deprived from applying in any post.
Lord, if the college come up with a press advertisement, Lord, if I applies,
That's why I have given that liberty.
there may not be weightage for the period.
No, weightage that I can't say. That is for the
At least
them to
something
say.
will not. My lord.
So that is why I added that line
Lordship,
to give you a liberty, because yes, you have spent time and Mr. Mukhtar is with you.
my lord. Obliged, highly obliged.
Mr. Mukhtar, I'm sorry, I came to know about the death of Rakibuddin's brother, but I couldn't get time to go to him. These days were very hectic.
Very busy, sir. Because of the petty terms of your lordship, sir, very busy man.
No, I'm involved in that, souvenir committee.
Yes, yes, sir.
And that therefore three publications came out in between. Souvenir is coming out. Assamese version of
That book, yes, sir, I-
Heritage has,
History book by
that has come out yesterday.
Yes.
Atman has been released. I'm not there in Atman, but still three literary
Yes, yes.
events so. To express my confidence, I'll go there. and see.
Obliged.
See, exactly similar lordship, college is defined only. Petitioner is absent lordship, so any other day lordship without petitioner is absent lordship.
Okay. Now the case will call for the petitioner.
Petitioner,
As per the, how Mr. K. Gogol and its Standing Council for the Higher Education Department submits that this case is similarly situated with the with the WPC 2389 of 2019. Which has been disposed of by order passed today. As far as it may, as the petitioner is absent on call,
lordship.
matter is deferred today. In this chapter, ensuing new witnesses.
It was a take matter lordship. This matter was take with this earlier matter.
So that's why
Yes,
this matter is detached and listed after the petition.
Lordship, oblige lordship.
Yes,
I'm explaining for response number 6, 9 and 16, madam.
yes.
After the honorable High Court order, madam, altogether 2,600, 2,586 other teachers amount had been released. And we have conducted a re-verification if someone is left out. Then the re-verification, we found out that 314 is still there. We have not received the amount. Then a supplementary demand was raised of 1 crore 17 lakh 75.75. And that supplementary demands was raised by the director to the.
No, you see, you may have verified and paid to 2,000 people. We are not deprecating that. But you only need to show that the petitioner's cases have been covered and they have been paid.
Yes, I'm coming to that point. After verification, we found out 314 is there. We sent the director sent it to the secretary of the PTC that this amount is this supplementary demands is paid. Then it was forwarded to the Woodland Welfare Department of the state of Assam. Then this is my affidavit. In the meantime, just now I received an instruction that after that amount has been rejected, and Woodland then the secretary of the Woodland Territory Mala, they have issued that 1,70,000 per amount, 1 crore 17,74,800 some amount on 23rd March 2023. Now that 314 people who are due, they will receive.
No, you see, Mr. Sharma's case is that his membership, the members of their association is more than 800 something. He said the figure, more than 800 something. So the only exercise we need is that whether the members of the petitioner is covered or not.
This is after verification, re-verification. That one, it is over that particular time with lordship, that particular petition, madam. Who are the members that is not been there? We are the members. Only on the representation, a sudden word is been added. In the lordship terms of the contempt petition, suddenly a number has been figured out, that is 681. Nowhere in the entire petition it has said these are the members. And a representation after the order, a number has been.
But when the writ petitions are heard, you don't take that objection. Now I can't go behind that. Once you accept it,
We have to make a verification. That verification was done. That's why, my lord, in verification, we found out 2,586 persons. And again, re-verification, we found out we left out 340.
You see, you have got your Paravise comments. You have a copy of your Paravise comments.
Lordship.
You take out that. It is in my this one in my file. It is dated 21/10/2019. You see these two pages. That is why when copies of this are handed over, yes, this is your Paravise comments. Last part. 2, 5 so and so members. Members. So you have used the word members. Therefore, you are aware who our members are.
Yes, that amount, my lord.
No, members. Members would be of association only.
Yes, my lord.
Contempt.
Yes.
So you
my
can't say that we don't know how many members are there. And next page. Now you say you don't know why they are not getting the amount.
lord. Now what my friend is insisting that we have another number, that 2-5, Lordship will see
No,
that.
I'm not on that. You see, there are two parts of it. Number one, you have referred to 2,500 members.
2,586. That amount will be released. That amount released.
No. What I'm trying to say is that now you are raising a question that you don't know how many members are there. But that is something which is known to you otherwise,
And
members.
That was known to me and it has been released. Then another re-verification was done. Then 314 came out. Secondary verification, we found that these 300 odd people, the L form was not sent. Then the supplementary demand came up, madam. This amount has been released, madam. There's all this. I have filed my affidavit on this regard, madam. Because Lordship take up my affidavit of response number 6. The principal secretary, madam.
Just give me that record. Lost my time. Mr. Sharma, you have a copy of that order in order dated 10/4/2012 in WPC 864 of 2009. Do you have a copy of that order? It is referred to in page 42, para 7.
In for 2012 order lordship.
Yes, 10/4/2012.
That is in lordship page 26 of my contemplation.
Page 26. Okay. But this, how many members you have? We don't have, you're not stated here.
Lordship, after this order, the Bishop lordship rejected my claim by order dated lordship page 31. They rejected our claim. Then we again filed this petition lordship. By this order at page 31, they rejected our claim and another order lordship at page 33. They rejected our claim. Then we challenging this order, we filed this petition lordship being the WPC number. It lordship
It's 7804.
Lord. In this repetition, Lord, the Honorable Court directed the respondent authority while the Lordship was passing this order to direct. So we this could direct the area side of the members of petitioner association number 1 for the
But then you
period
have
question.
to, that's what I'm saying. In these two orders, I don't find that there is any reference to how many members you are having. So it can't be unending exercise.
Lordship will always find a number.
The Honorable Court did not Lordship mention the member of our association, though it was before the writ court. So I mentioned in my representation, Lordship.
Yes. Only
Then
the representation.
we'll tag this writ petition together.
Lordship.
Okay. But Mr. P. Sharma, learned counsel for the petitioner, also heard Mr. S. Bharat, and standing counsel for the BTC.
Contempt, my lord, happy only for 9 and 16.
Also for
9 and 16.
9 and counsel for respondent 9 and 16. And Mr. A. Das, learned counsel agreeing for respondent number 18. And Mr. R. Dhar, then counsel for respondent number 8. Next para. It is submitted by the learned counsel for respondent number Mr. Bora, you are
9 and 16.
9 and 16 that an amount of rupees 944,77,913 was released as outstanding arrears salary to 2586 mother teachers. It is submitted that on a subsequent verification, re-verification,
It was detected that 314 still. is being-
it was detected that 314
Mother teacher.
mother teachers had not received their arrears payment. And therefore, the BTC authorities have sanctioned a further amount of rupees 1,17,74,859 for paying the arrear salary of 314
14.
mother teachers.
This is the last order, Lordship, in the month of March.
23rd of March.
23rd of March. It will be released then.
To provide an order dated, communication dated 23/3/2023. And it is submitted that the said amount will be released within a short time.
If you have to look at the last page of the bunch, your lordship.
Last
Later
page of
it
the
is 29th of March.
29 March, it has been
It
released.
has been released.
And it will
It has been released.
Okay, and on 29/3/2023, the said amount has been released. Next paragraph. At this stage, the Learned Council for the petitioner submits that there are 800
No, my lord. 681. Lordship.
681 members of the petitioner association. And the salary of all the members have not been released. Next paragraph. It is observed that in the order of this court dated 8/11/2016. No, not 8/11, it is
18-1 to
18/1 to 19.
18/1/2019.
And that in the
No, this
have
one.
to be now 44.
Passed by this court in WBC 2804 of 2016. As well as in the order dated 10/4/2012, passed in WBC 864 of 2009 by the petitioner association, filed by the petitioner association.
Lordship, if I can.
The number of members of the petitioner association has not been mentioned. Yes,
If Lordship has to pay now 44. When the order was communicated by the petitioners association, pay now 44 to petitioner, then in the next page, my lord, page number 45, he came up that particular number, 681 mother teachers. Second line.
He has not read the entire sentence. I further said that we have submitted a list of member of our association containing so and so in the Honorable High Court. We submitted before the High Court
it's okay.
in the writ petition.
Okay. Next paragraph. It is noted that in the representation dated 4/2/2019, submitted along with a certificate copy of the court order to the Director of Education BTC, the reference is made that the association had has membership of 681 mother teachers, which was produced before the High Court. Next, accordingly, to have more clarity in the matter, the court is inclined to direct the registry to take the records of WPC 7804 of 2016, disposed of by order dated 18/1/2019, as well as the record of WPC 864 of 2009, disposed of by order dated 10/4/2012, when the matter is listed next. Next, in the meanwhile, the petitioners may also file an additional affidavit to bring on record their membership list. As on the date when WBC 7804 of 2016 was filed. And indicate the members whose aided salary has not been released till date.
Lordship, I have already submitted one affidavit reply in which I have submitted the lordship list. In this content list. On 7/11/2020.
That annexure 14,
Lordship.
annexure 14.
Lord.
No, this is the name of who the members of.
Our
Okay.
official command. This list is submitted.
Acha, okay,
before,
okay,
report.
Then more you will say that the Learned Counsel of the petitioner has submitted that in the additional affidavit, affidavit in reply filed in this matter, or the list of mother teachers who are members of the petitioner number one association is already disclosed. Accordingly, the respondents shall go to the additional, the list next to the affidavit in reply. And inform the court as to whether the payment has been released to all the members of the petition as petition number one association. So the court grants 4 weeks time to the respondents to undertake the exercise. List on after 4 weeks, give a date.
So can it be a 15 if convenient?
No, no, sorry, that 15/5, okay.
How that is?
Your instructions, I'm giving it back.